Greetings, welcome to another episode of Knowledge is Power in conversation with Dr. Mrs. Challa Mahalakshmi, an eminent lawyer of repute in Visakhapatnam, a city of destiny in India, and who did her doctorate in constitutional laws. She will be now explaining us about the provisions of Hindu Marriage Act in a nutshell. Over to Dr. Mrs. Challa Mahalakshmi.
Hello. I have to mention that this act is exhaustive and for the benefit of the non-legal persons, I go through only important basic points for guidance. For details, one can reach us on phone. First, we will discuss about how this act applies, whom this act applies. This act applies to all Hindus, including Sikhs, Jainas, Buddhists, and any person who is resident of India. This act does not apply to Muslim, Christian, Parsi, or Jew who are Hindus. All Hindus, Buddhists, Jains or Sikhs by religion, any child legitimate or illegitimate of whose parents are Hindus, Buddhist, Jain or Sikh by religion. Any person who is convert or reconvert to the Hindu, Buddhist, Jain and Sikh religion. A marriage may be solemnized between two Hindus when the conditions are fulfilled. No party has spouse living at the time of the marriage. No party is incapable of giving valid consent to it in consequence of unsoundness of mind, or even though capable of giving consent but suffering from mental disorder to such an extent to be unfit for marriage and procreation of children, or has been subject to recurrent attack of insanity, and the groom has completed the age of 21 years and the bride is 18 years of age at the time of the marriage. The parties should not be within the prohibited relationship unless the custom governing each of them permits a marriage between them. The parties should not be subpoenas. Ceremonies for a Hindu marriage. A Hindu marriage is solemnized in accordance with the customary rites and ceremonies of either party, where such rites and ceremonies include the Saptapadi jointly before the sacred fire. The marriage is complete and binding when the seventh step is taken. The restitution of conjugal rights. When either husband or wife withdrawn from the society of the other, the aggrieved party can file petition in court for restitution of conjugal rights. The burden to prove is on the person who has withdrawn the society of the other. Judicial separation. Either party to the marriage may present a petition in court praying for judicial separation, where a decree is passed for judicial separation. The petition has no obligation to live with the respondent. Nullity of marriage. and divorce. Void marriage is that if it contravenes any conditions that any party to the marriage has a spouse living at the time of marriage, when the parties are not within the degrees of prohibited relationship, the parties are not subpoenas of each other. On a petition presented by either party be so declared by a decree of nullity, or as the marriage is null and void. Voidable marriages. There are marriages where court can declare voidable on a petition by either party to the marriage when the marriage is not consummated owing to the impotence of the respondent. When the marriage is performed and one of the parties to the marriage incapable of giving a valid consent to it in consequence of unsoundness of mind, or though capable of giving consent has been suffering from mental disorder to be unfit for marriage and procreation of children, or has been subject to recurrent attacks of insanity, or that the consent of the petitioner, or where the consent of the guardian in marriage of the petitioner was required, the consent of such guardian was obtained by force or by fraud, or that the respondent was at the time of marriage pregnant by some other person other than the petitioner. Divorce. Any marriage may on petition presented by either party, that is husband or the wife, be dissolved by divorce or a decree of divorce on the ground that the other party after marriage had voluntarily sexual intercourse with any other person and has treated the petitioner with cruelty and has deserted the petitioner for a continuous period of 2 years and has ceased to be Hindu by conversion to another religion and has been incurably of unsoundness of mind or suffering from mental disorder to such an extent that the petitioner cannot live with the respondent and has been suffering from a virulent, incurable form of leprosy and has been suffering from venereal disease in a communicable form and has renounced the world by entering any religious order and has not been heard of as being alive for a period of 7 years or more. There are some more grounds for dissolution of marriage. Either party to the marriage may also present a petition when there was a decree for judicial separation and there was no cohabitation between parties for a period of 1 year, and when there was a decree for restitution of conjugal rights and there was no restitution of the same for a period of 1 year or upwards. A wife may also present a petition for a dissolution of marriage and for a decree of divorce when any other wife of the husband was alive at the time of the marriage and that the husband is guilty of rape, sodomy or bestiality and that her marriage was solemnized before she attained majority. Divorce by mutual consent. A petition for dissolution of marriage by a decree of divorce may be presented to the court by both parties together on the ground that they are living separately for a period of 1 year or more and they have not been able to live together and that they have mutually agreed that the marriage be dissolved. No petition for divorce can be presented within 1 year of marriage unless with the permission of the court. Divorced persons can marry when the appeal time is over or the appeal is dismissed. Children born to the couple in void or voidable marriages are legitimate children. The husband or wife at the time of their marriage, either of them had a husband or wife living, there is punishment under bigamy. Jurisdiction for filing petitions and the procedures. Every petition shall be presented in the original civil jurisdiction within local limits. Where the marriage took place, where the respondent at the time of the presentation of the petition living, where the parties last resided, where the wife living at the time of filing the petition. Every petition presented under this Act shall state clearly that there is no collusion between the parties and it should be verified by the petitioner or any person competent to that effect. As per the Act, every petition shall be tried as expeditiously as possible on day-to-day basis, and the appeals also should be heard as expeditiously as possible and should be disposed. This Act provides in camera proceedings. It's not lawful to print or publish any matter in relation to the proceedings except in High Court and Supreme Court with previous permission. Maintenance to the petitioner may be granted by the court when the petitioner is not able to maintain due to financial disability, taking into consideration of the income of the respondent. This Act provides power to the court to grant permanent alimony and maintenance on a petition. In a proceeding in this Act, the court may pass interim orders for custody of minor children and maintenance and education of minor children wherever possible. The court may also from time to time revoke or suspend any order previously made.